Hello, my name is Tom Hartmann with the Hartmann Law Firm in Watchung, New Jersey. Today I'm going to talk to you about mediation as a way to save time, costs, and emotional burdens associated with disputes. Litigation costs are astronomical. Before you even get to the substance of the litigation, you are likely to spend 300 to 500 days on discovery, depositions, interrogatories, document requests, subpoenas, and then disputes about that, motions back and forth about that, before you even get to the possibility of having a judge or a jury make a decision on your case. And while you're doing that, you're paying lawyers and others great deals of money, at great expense to you and your family. So you should think about ways to resolve the issue, because litigation is not the goal. Litigation is a method or a process for you to solve the dispute. One possible way to solve a dispute relatively early and relatively cost efficiently is mediation. It's not a perfect solution for everything, and timing is important, and who you pick as a mediator is important. But it offers something that the parties can use, the parties can control to decide how to proceed, as opposed to litigation where the judge uses a very sharp knife or the jury uses a very sharp knife to reach a conclusion. You either win or you lose. There may be variations within there, but you certainly are not necessarily going to get what you want. And if you don't get what you want, you can't go back and change your mind and say, I'll compromise, because the judge or the jury has made his or her decision. The same with binding arbitration. But with mediation, you pick the mediator, you pay the mediator, you meet in a place that's not a judicial building or in a legal setting. You meet in an office location, and you present your position, and the other party presents its position, not following the rules of evidence or the rules of procedure. Now, who do you pick as a mediator? In some jurisdictions, in some vicinages in New Jersey, there are voluntary mediators. In other cases, the court orders a mediation and then asks people who have been designated as potential mediators to participate. Those are not necessarily judges, and usually they are not retired judges. My own preference is for a retired judge, because a retired judge who's been on the bench 10 or 15 or 30 years has dealt with disputes, significant disputes, and they've learned how to solve the disputes. And they come with a certain gravitas to the table, and they can explain to people, I know how to solve your problem. I know how to listen, I know how to organize the facts, and I know how to help you solve your problem, compromise, and come to a good solution. Now, it's not a panacea, mediation. It may not work in every case, but it often works. It's not necessarily inexpensive. It will save you money in the long run if you can solve the problem, but most of those judges I was talking about charge between $400 and $600 an hour. And you say, that's an awful lot of money. It is, but you're not going to be involved in the mediation for very long. If you're able to solve the problem, or if you're on the road to solving the problem, it will take probably a day to 3 days at the most to resolve the mediation. And you're paying half of the mediator's fees, not all of the mediator's fees. This is on top of your own legal fees, but still it's half of it. And if you solve that problem, you probably spent 1%, 2%, 5% of what you would have spent on litigation. And you have to be careful when you try the mediation. You can't approach mediation from the 50,000 or the 30,000 foot level. You have to approach it from the very detailed, concrete, I want to get this done level. So you have to have some discovery. You have to have the documents. If you're seeking a certain level of damages, you have to have the support for that. If you're trying to prove or establish that you've been wronged or that the contract has been violated, you have to be able to show that. Not in the same way that you might have to show a judge or a jury in a formal legal setting, but you have to be able to explain to the mediator so that the mediator can then advocate your position to the other side or tell you where you're wrong. The mediator might tell you you're wrong. That's another useful part of mediation. They can explain, I've been here before. That theory, those set of facts won't work. On the other hand, the mediator can say, I have been here before. That makes sense to me. Let me go talk to the other side. And then you have to have the right mindset when you approach a mediation. If you go into the mediation demanding that you get everything that you sought in the litigation from the start, it's likely not to be successful. You have to approach it with a bit of a conciliatory attitude so that you're willing to give as long as the other side is willing to give. You don't just give up, but you're willing to compromise to get to a rapid solution, to get to a cost-efficient solution, to save money, and ultimately, Ultimately, the purpose of the mediation, like the purpose of litigation, like the purpose of any dispute resolution process, is to end the fight in a way that makes you feel comfortable that you have accomplished your purpose. This is Tom Hartmann with the Hartmann Law Firm. If we can help you with any of your personal or business legal needs, please call or visit us. Our telephone number is 908-769-6888. Good day.